Uh, Orgo began by calling me a victor, and I'm really dismayed and saddened that very few people have appreciated the judgment. This is a rare case where the court had an opportunity of deciding a case on the basic structure. Now, we had this in 1973, and if you take constitutional history, before this case, only 4 times a law has been struck down on basic structure. One was in 75, the 39th Amendment, Indira Gandhi versus Raj Naren. The next was in 1980, the Minerva Mills case. Then you had 87, the Sambamurthy case with 32nd Amendment, part was struck down. And then you had Kyoto Holoan, which was in 1993. And now we had, after a gap of 12 years, the latest 4th judge's case, as you may call it. I'll just mention 2 things here. Nobody has thought that what would happen if the case had gone the other way. What would have happened to our judiciary if the judgment had gone in favor of upholding this particular amendment? And Mr. Raju Ramchandran mentioned that we have reached the level of a bricklayer as far as things concerned. And if I take this civil engineering metaphor, I would say that the person who drafted this particular law was neither an engineer nor an architect nor a bricklayer. Elementary knowledge of drafting, the drafting is so pathetic, it had to be struck down. There's no doubt about it. Mr. Ganguly mentioned that this judgment says that nobody will be included. I am sorry. Please see para 60 to 67 of Justice Ker's judgment. He has mentioned the participative role of the executive, how many times the file goes to the Chief Minister, the Governor, and so on. And on the flight from Chennai, I saw an article of Mr. P. Chidambaram, who takes ignorance to a very, very high level. He simply says that this judgment means that nobody is fit to be consulted. I mean, for God's sake, read the judgment before you criticize it. Now, this I wanted to mention on the basics of basic structure, and I'll go on to my thing of composition. Now, one reason why this law was struck down was simply hopeless draftsmanship. Take Article 124A. Now, if you see 124A, first of all, it said that there will be 6 members of the collegium. Now, anybody knowing company law, anybody knowing any law of meetings, knows that a meeting always has an odd number. You don't have even numbers, elementary. And if you have that elementary foolishness, then at least provide a casting vote. You say 3 judges, law minister, and 2 eminent persons. Now, why did the Supreme Court strike it down? I mean, everybody is criticizing the judgment is gone, its judges have become imperium and imperio and so on. Now, look at the consequence of this particular amendment, how absurd it is. Eminent persons. The law says that there will be 2 eminent persons who will be on the panel. Who are these eminent persons? Even God does not know. Attorney General mentioned that it could be Dr. M.S. Swaminathan, who incidentally is an agricultural scientist from Chennai. Why not Lata Mangeshkar? Why not Sunil Gavaskar? Now, we told the Supreme Court that the word eminent persons has been used in 70 statutes, central statutes and state. Just search it in Manupatra, you will find eminent person, or in SEC online. You will find that it has been used in 70 state and central statutes. In 67 out of 70 statutes, they have said eminent in the field of what? National Law School University Act, eminent in the field of law. Biodiversity Act, eminent in the field of zoology, biology, biodiversity. Lok Ayukt Act, eminent in the field of science, management, economics, administration, and so on. Now, it baffles me. You are talking of amending the constitution. You are talking of appointing people who will decide who will be the judges of our country. And you don't choose to put who the eminent persons are. That's one point. Now, secondly, the Constitution, Article 124 says these 6 people will be there. But strangely, the Act, which is one step lower, says there will be a quorum. Now, out of 6, which will be the quorum, which the regulation may decide. How will they carry a veto? Regulation may decide. Who will be consulted? Chief Minister, Governor? Regulation may decide. There are 17 times where it will be decided by some regulation. Now, first of all, in a meeting of a body which is going to decide Supreme Court judges, you have a quorum which is not known. You have a concept of veto power. Any 2 persons can veto the appointment. Now, ironically, 99th Amendment was actually the 122nd Amendment Bill. It became the 99th Amendment Act. It was the 122nd Amendment Bill. if you get time, please see the 121st Amendment Bill. Okay? That is the GST, Goods and Service Tax, another appalling law which is going to come. Now, the 121st Amendment Bill also has meetings. Finance Minister, somebody from the center, and one Finance Minister of each state government. And Article 279A in that draft amendment provides how the voting is to be carried out. So we told the court that when you talk of goods and service tax, you provide how the voting is to be carried out, but in a constitutional amendment appointing judges, you say it as may be prescribed. Now there is no time, I've got
3 minutes.
3 minutes, yeah, I'll try to keep my timing. Yeah. Yes, I've got 2 minutes actually. Now the other point is, look at the bad drafting. Now the NJAC, the National Judicial Appointment Commission, consisting of the top 3 Supreme Court judges, the law minister, the 2 eminent persons, let us say the 2 most eminent persons in the country are chosen whose ability is not doubted. Now they frame elaborate regulations as to who should be the Supreme Court judge, who should be the High Court judge, what are their qualifications. Regulations are framed. Now section 13 of the Act says that this regulation shall be tabled before Parliament. All of us know who are lawyers, there is something called tabling provision. In the Excise Act or the Income Tax Act, when the notification is issued, it is tabled before Parliament. Why? Because it's a delegated legislation, it is subject to supervision by the primary legislature. Now, somebody in drafting, the bricklayer or one step below that, has taken a provision of tabling in all tax and regal statutes, bodily lifted into the NJAC Act. What is the consequence? All these 6 eminent of eminent people draft regulations, it is placed before Parliament, and Parliament can modify, annul, supersede these regulations, and the modified regulations will apply. Do you realize the absurdity of it? A constitutional body frames regulations, and a Parliament with a simple majority, suppose there are only 60 people, 54 is the quorum, 60 people sit there, they can amend the entire NJAC Act. So I told the court when I argued, I said this NJAC regulation has no better status than a notification fixing the rate of toothpaste. I am not exaggerating, this is the absurd level to which drafting had been drafted. And I am sorry to say that not one writer has bothered to see why the Supreme Court has struck it down. Could you defend such a law? Can you defend a law which says there will be 2 eminent persons whose qualification is not known? Can you defend a law which says the regulation shall be tabled before Parliament and Parliament can modify it? I don't think so. And what I told the Supreme Court was, in part of my arguments, that look, nobody supports the collegium, and I want to make it clear, we do not support the collegium. We said again and again that you can follow the Venkatacharya recommendation, out of 7 members, keep 4 judges, it is more than enough. We never said that collegium is the only thing. But what we said is, whatever you do should be basic structure compliant. So whatever law you make must give judges the primacy. And now they say that independence of judiciary, I must just mention one point and I'll wrap up. Independence of judiciary is part of basic structure. Okay. So you got basic structure, a subset of it is independence of judiciary, and what this judgment has done, in my opinion rightly, not because we won but rightly, is that primacy of the judge's opinion is a subset of the process. So you got basic structure, independence and primacy of judiciary. So my submission to all of you is that it's a perfectly correct judgment. The composition was so bad that it had to be struck down, and all of us should be glad rather than happy at the outcome of this judgment.
Friends of the judge.